Lady Justice Susan Okalany, thank you so much for joining us for this interview today.
Welcome.
We are going to be discussing the recently handed down decision in the Thomas Kwoyelo case. And I would like to know, what is the impact of this decision?
For us as a court, the impact is very big. It is a precedent, really, for accountability for atrocities or egregious crimes or international crimes. So it has set the pace on what should be done every time we have such crimes in our jurisdiction.
Could you tell us what were some of the challenges that the International Crimes Division faced when dealing with this case? And also, what are some of the lessons that have been learned?
We did have a lot of challenges, really, in the prosecution of that case. Firstly, I think the biggest of the challenges was the legal framework. We have the Amnesty Act, which enables persons who have committed crimes to admit their crimes and to be processed through the Amnesty Commission and forgiven, basically, by the head of state. And so many persons suspected of having been involved in the LRA conflict as criminals or suspected criminals were given amnesty. And some of them were very high-level commanders in that war. And because of that, Thomas Kwoyelo himself, when he was prosecuted, or when the DPP prosecuted him, took him to court, decided to challenge his prosecution, basing on the fact that his superior commanders in the LRA who were more superior to him, had not been prosecuted, had been granted amnesty. The decision of the court was that he was not eligible to amnesty, having been suspected of having committed serious crimes. Basically, the court ruled that whoever is involved in committing atrocities, atrocious crimes or international crimes cannot benefit from amnesty. So because of that kind of conflict of laws, we delayed the prosecution, even during the trial. When I was appointed a pre-trial judge of the case, I was faced with the challenge of what crimes can he be charged with? Should he only be charged with penal code offenses, since the prosecution had amended the charge sheet or the indictment to include war crimes and crimes against humanity? And yet, there was no specific criminal provision that they were relying on. They were relying on customary international law to bring those charges. And that was because the Rome Statute Act that provides for prosecution of war crimes and crimes against humanity and any other international crimes was not law at the time of commission, the alleged offenses. Mm-hmm. So there was a gap in the law. So apart from legal framework, there was generally the issue of capacity in the prosecution, in the police, in the judiciary itself, in handling those crimes. Like most of us, even when I did the pre-trial, I was resident judge of Mbali. The judges that have now heard the case and convicted Thomas Kwoyelo are judges of different divisions and courts. You know, we borrowed them, so to say. The principal judge assigned them a special task. But they are very busy judges in their respective courts, handling thousands of cases. And that meant that they could not sit continuously in hearing Thomas Kwoyelo. There would be complaints in their own other courts. Of course, when all those issues of victims' participation arose at the pre-trial, including the customary international law, preliminary objection, those were not common questions that had been determined before in our courts. And so it was the first time that we were dealing with them. What I didn't talk about was resources in terms of finances. That was a huge problem. There was always this question, even when the principal judge agreed with the judges of the International Criminal Crimes Division to increase the amount of money that was being spent in hearing the case. There has always been comments thrown here and there by our own colleagues in the judiciary about how one case can take 400 million shillings per quarter. So we should factor in the issue of the cost of hearing international crimes, knowing well that the purpose, I mean, the mandate to hear, to try or to bring about accountability for war crimes, crimes against humanity, and other international crimes rests primarily with the state. It does not rest with the ICC. And because we delayed and did not properly have resources or resource ourselves, the accused person in that case kept on pleading with the trial judges that he should be taken to the ICC because Dominic Ongwen trial started after hours, of the Thomas Kwoyelo hearing, and was concluded before. But of course, again, he probably did not understand the challenges that the division was faced with. We also did not want to have an accused person being prosecuted for such a long time and not seeing the end to his case, whatever the outcome.
Would you say that having an international crimes division was something that was very useful in a case such as this? And I'm thinking about other countries which do not have this type of specialized divisions, whether for them this would be something that they should be considering to establish.
Yes, the answer is yes. I can imagine if we did not have the court the way we have it, the structure that we have, however weak, how difficult it was going to be. There's a need for a specialization, specialized cadres of officers, judicial officers, prosecutors, investigators, which we do have in Uganda with some training. So specialization is important. A special unit is very important. I would advocate for it for any other country because one needs to be prepared in advance. We are living in a world that conflict is a possibility. So having a special cadre of persons prepared well in advance as an emergency response, if I may call it, to accountability for atrocities is something that must happen.
You talked about victim participation, and now that we have a conviction in this case, obviously victims will be looking to see what else they get from the process. So does Uganda have a reparations framework or a legal framework that governs reparations? And how do you think the country should deal with this issue?
At the moment, for atrocity crimes, the only framework that we have on reparations is the National Transitional Justice Policy, which, from the information that I have, the Ministry of Justice is working to convert it, I could use that word, into a law. There is a draft Transitional Justice Act that would implement the issue of reparations in full. Now, of course, for some crimes like the sexual violence, cases of defilement, cases of robbery, there's a specific provision in the Penal Code Act for compensation. That is the type of reparations that exists in our law. So we, apart from the policy, we don't have a reparations framework that covers the case of Thomas Kwoyelo, a national reparations law. However, because we allowed victims to participate, and because of our international obligations, I believe that the court will rely on our international obligations to provide some form of reparations to victims, symbolic reparations, and many other reparations. When we did the last outreach, they were talking about reburials. They want exhumations of their loved ones who were buried in camps to return the remains to their localities where they have now gone. Symbolic reparations like monuments, the construction of churches in some of those sites, reburials, which I have mentioned, apologies, and financial, some cash reparations to enable them begin in life. There were issues of land for children born to victims of rape and sexual slavery. These children are not recognized in the communities where their mothers are coming from because they are regarded as children of the enemy. And so they have no land, they have not gone to school, they have no expertise, any form of expertise to survive, you know, and they have almost lost their destinies, and they need to be rehabilitated. Another thing that came up so much was in that outreach was trauma rehabilitation, psychosocial support, bullets, extraction of bullets from bodies. We met victims with bullets still lodged in their bodies, and they just want the bullets taken out. In some of the operations, they could be establishing or empowering health centers with the requisite staff or experts coming from other countries that can conduct those operations and relieve these living persons who are still young and have probably decades to live from the trauma they are faced with, psychological trauma, and also physical trauma, which can be corrected.
So this has been a very long road, a very long journey. So where does the ICD go from here? Where does Uganda go from here in terms of international crimes cases? Should we expect more?
Yeah, I think this is a test case. I believe that this should be a test case. For the so many atrocities that were committed in the LRA war, it cannot just be enough that the only accused persons who have been brought to account are Thomas Kwoyelo and Dominic Ongwen. That would be sampling and expecting everybody to clap for us, you know, for what has been done. I think this is just the beginning. For deterrence to happen, for justice to happen to the majority of victims who are not engaged in the Thomas Kwoyelo, Dominic Ongwen convictions, whose cases are not covered by those two convictions, I think there should be prosecution. The Supreme Court made it clear that whoever was given amnesty and should not have been given amnesty deserves to be tried.
Lady Justice, thank you so much for your time. It was a pleasure to have you.
Welcome. My pleasure.
Thank you.